My Lords, Lord Mance hinted that it might be useful to go to the UN Convention, and so I'll do so very quickly. If we turn up Appeal Authority Bundles Volume 4, tab 29. Page 1115. This is what the convention looked like in one of its final drafts.
Right.
And it's Article 21 on page 1115, state immunity from measures of constraint. And there's a reference there to a state enjoying immunity in connection with a proceeding before a court of another state for measures of constraint, so we're talking about execution, including any measure of attachment, arrest and execution on the use of its property or property in its possession or control. Now that's how the draft started off. What then happened in the hiatus of some 10 odd years to get to the final version, that wording came out and they reverted to simply the label property of the state. Now, according to the commentators who have ploughed through all the travel, this did not make any difference to the concept behind the new wording. And if we see that, if we look at Volume 5, tab 39, 1, 3, 4 through.
Is this a point that the commentators make on their own authority, or is it based on something in the Travo?
My Lord, I have to concede that we don't have the travel where this point is being made. But this is how it's understood by at least the leading commentary on the UN Convention.
Flag?
39, is it?
39.
Sorry, could you give me a page number?
I'm afraid they've been blanked out again.
Oh dear.
1341.
Thank you very much. It's page 316
Yep.
at the top.
Right.
And it's a commentary as to what property of a state means in the actual final version.
So which page at the top is it?
316.
316, okay, right.
Yep.
Sorry, what is this work?
Well, this is an academic commentary on the UN Convention. And it's,
Right, by... I mean, this part of it I can see is by Tom Grant, but...
it's by O'Keefe and Professor O'Keefe and Professor Thames.
yes. No,
It's the only commentary
that's well known.
that we're aware of on the convention. But they say, he says, recourse to the travel préparatoire to resolve the ambiguity as to what property of the state means indicates plainly that the second reading is the correct one, the words property of a state having been proposed as shorthand for the formulation its property or property in its possession or control, adopted on first reading, are to be construed as referring to any property that a state owns or that it possesses or controls.
But I think the one thing that we ought to be a bit cautious about, however distinguished the authors of this Oxford commentary, is taking it from a textbook as gospel. In other words, if we're going to rely on the travaux préparatoires under the Vienna Convention, we need to see them.
Yes.
So you'll have to do quite a lot more homework to back this up.
On the face of it, the conclusion one would draw from the change of wording was that the previous one was thought to be too wide.
Well, that would be an appropriate inference from an English law contract drafting process.
It would be appropriate
would apply here.
Well, it would also apply, in fact, to the usual reason why wording is changed in international convention. You can't get support for a wider view, so you resolve the differences by moving to a narrower one that more people can accept. But, I mean...
This is all theoretical.
The Travo will clear that up.
We've got to see the material. This is an important point, and
Lord, at least
how long is it going to take you to produce it?
Well, we'll do our best overnight, my Lord, if it indeed exists. But the problem
Well,
with...
of course it exists. I mean, the authors refer to the travaux préparatoires, which they say resolves the ambiguity. So they must be relying on something.
Well, you should find the answer in the International Law Commission papers
Yes.
of the
Yes.
United Nations, which
They seem to
are
say
very readily available on the internet.
recall, they refer at the bottom to recall sections 2.1 and 2.2 without giving a date, but as my Lord says,
We'll do our best overnight.
well, I think what we're more interested in is, since we're not going to write any advice to Her Majesty overnight, is the accurate answer, and if you take a week, that's not going to be a problem.
We will do it as quickly as
And
possible.
obviously both sides should have the opportunity to contribute to whatever is put before us.
My Lord, I was going to then turn to part 7 of my submissions dealing with the respondent's case on section 14. And I start by making an obvious point that's sometimes lost in the fog, which is that all immunities are vested in the state as a subject of international law. To the extent that someone else, an entity or person, is able to assert an immunity, it's the state's immunity that's being asserted. So it's not strictly correct to say that separate entities do or do not have sovereign immunities. Only sovereigns have sovereign immunities. A sovereign state's immunity may extend to certain acts performed by a separate entity if those acts are based upon the state's sovereign authority, or certain property held by a state entity if it's being used for a sovereign purpose. But it's never a question of distinguishing between immunities vested in the state entity, separate entity on one hand, and distinguishing those from the state's entity and somehow ensuring that they don't overlap. That's not a correct mode of analysis. It's the state's immunity at the end of the day that we're talking about. All immunities reside with the state. Now, it's common ground that Botaş is a separate entity. Question whether or not that's relevant in the present case. We submit that it is not, because the question is simply whether Botaş's shares in TPIC and Bill are protected by Turkey's immunity from execution. The Court of Appeal came to that conclusion, and that's at paragraph 83 of the judgment on the record at volume 1, tab 2, page 50. Now we say the shares are protected from execution because the Republic has the requisite control interest in them. Respondent disagrees, and I want to take you step by step through the arguments they make in that direction. And this is at paragraph 3.4 of their written case, and they summarise their propositions. And the first thing they say is that even though it's conceded in the present case that Botaş is a separate legal entity under section 14, subsection 1, the inquiry as to whether the Republic has a claim to sovereign immunity in relation to the assets of Botaş should always start with
Which
section...
paragraph are you reading from?
This is 3.4, my lord. But I'm going to jump now to paragraph 67, where they give the reason why you have to start, apparently, with section 14 if it's a separate entity. They say this at 67. The general policy of the State Immunity Act is that states should not be immune for commercial trading activities. So far, so good, we agree. Next sentence, though. This is reflected in section 14.1, which expressly identifies which persons or entities constitute the state for the purpose of the Act and are thus entitled to claim sovereign immunity subject to the exceptions, and separate entities which are not entitled to claim sovereign immunity.
Sorry, where are you reading from now?
Paragraph 67
Of
the written case. The
Of your
response written
case?
case.
No, that
Of their
respondents.
case. Oh, we've gone. Right. Yes, I see.
I do apologise, I'm
No,
having to move rather quickly. But
yes, carry on.
we say, my lords, that the fact that separate entities are not included in the definition of the state in section 14 has precisely nothing to do with the restrictive approach to state immunity, and no authority has been cited for the respondent's proposition. Separate entities, in other words, my lords, were not taken out of the definition of the state to somehow neutralise an aspect of the absolute doctrine of immunity, because separate entities were not generally entitled to immunity under the absolute doctrine. And the best illustration of this is the Trendex case. You recall that the majority of Lord Denning and Lord Justice Shaw decided on the basis of two alternative premises. First, they assumed that the restrictive doctrine would apply. And applying the restrictive doctrine, they said this transaction, which involved letters of credit entered into by the Central Bank of Nigeria, is a commercial transaction. Therefore, no immunity. That was applying the restrictive doctrine. They went on to consider what the position would be if they were wrong on that, and the absolute doctrine applied. And that's when they get into whether or not the central bank was part of the state of Nigeria. Because if it was a part of the state of Nigeria, with the absolute doctrine applying, then it would be immune, and we wouldn't look at the nature of the acts in relation to the particular transaction. So we see in that case the fact that the Central Bank of Nigeria made no difference to how you would resolve the immunity question if the restrictive doctrine applied, and of course it applies today. So the question is, well, what relevance does Lord Denning's test now have, given that the State Immunity Act has adopted the restrictive doctrine of immunity? I submit the answer is very little relevance, in fact. My lords, can I put it this way in fairly colloquial terms? Wouldn't it be quite bizarre if a separate entity could come before the court and say, well, actually, we're a sham, therefore we're part of the state, therefore accord us immunity? Because that would be the effect of the submission when the restrictive doctrine. So status under the immunity, and I've said this before, status under the State Immunity Act is now only relevant actually in one tiny residual area, and that's immunity from execution in relation to a central bank's assets. Section 14, subsection 4, it doesn't matter whether those assets are being used for a commercial or sovereign purpose. It's the one little area that the State Immunity Act protects absolute or retains absolute immunity. So if an entity comes before the court and says we're the central bank, then it will be necessary to determine whether or not they are in fact the central bank. But actually it won't make any difference whether that central bank is a separate entity or an organ of the state. Either or, under section 14, subsection 4, it makes no difference. The assets are entitled to absolute immunity. And the other point is that the UN Convention includes separate entities in the definition of a state. It can hardly be said that the UN Convention doesn't embody the doctrine of restrictive immunity, but it includes separate entities, and separate entities are included in the definition so long as they're exercising sovereign authority. So the fact that we have a provision carving out separate entities from the definition of a state in section 14 has nothing to do with the restrictive doctrine, and Trendex is a great example of that.
Well,
if we return...
It might just help to focus a bit more closely on Trentex in light of your slightly dense submissions on the point. Have you got time to do that?
One way of shortcutting that might be to go to Hemisphere, where it's quoted directly.
Fine.
So let's go to Hemisphere. And in fact, in 3.4 of the respondent's written case, I was going to start with this. They say that this matters, the separate entity point matters, and they quote Hemisphere. They say, because the status gives rise to a strong presumption that its separate corporate status should be respected and that it and the state forming it should not have to bear each other's liabilities. That's a quote from Hemisphere. Of course, Hemisphere is not a state immunity case at all, but it does talk about immunity. So let's go to Hemisphere.
Where is it?
It's volume 3, tab 18, page 645. And if we go to page 649 of the bundle, 713 of the report, you see at paragraph 3, the issue that is relevant to be decided in Hemisphere is set out. So the appeal raises important issues regarding the position of state-owned corporations and the circumstances, if any, in which they and their assets may be equated with the state and its assets. In this case, the issues arise in a claim to hold a state-owned corporation liable for the state's debts. In another case, the claim could be to hold a state liable for its state-owned corporation's debts. Then paragraph 4, in the courts below, the case was argued and decided on the basis that whether JCPC was an organ of the Democratic Republic of Congo was to be determined by a common law test derived from the English Court of Appeal's decision in Trendex. And then you see the quote from Lord Denning. It says, addressing the matter on a hypothesis that the court was still bound by the doctrine of absolute immunity, Lord Denning said, and there he says, if we are still bound to apply the doctrine of absolute immunity, there is even so an important question arising from it. The doctrine grants immunity to a foreign government or its Department of State, or any body which can be regarded as an alter ego or organ of the government. But how do we discover whether a body is an alter ego or organ of the government? So in other words, Lord Denning's test was in the context of applying the absolute doctrine of immunity. What relevance does it have now that we've adopted the restrictive doctrine? Very difficult to see how that test can survive. And as I said, it would give rise to the bizarre situation where a separate entity comes before the court and says, actually, we're the alter ego, we're a sham entity of the state, therefore we're part of the state, therefore accord us immunity.
It's not necessarily a sham entity.
Well, the test in hemisphere for deciding the other question
is they're exercising sovereign functions of the state.
Yes. But my lord, it's exercising sovereign functions in relation to the particular acts that are the subject of the dispute. The Trendex test looks at the relationship between the state and the separate entity in abstract terms. And that's not the test that we're interested in determining whether a separate entity is entitled to adjudicative immunity. We look under section 14, subsection 2, to the nature of the acts of the transaction which form the basis of the claim. So going through the Trendex factors, which looks at the whole thing in abstracto, is actually not what we need to do under the State Immunity Act. I mean, to put it slightly differently, a state entity which is for all purposes, completely separate from the state, may be given sovereign authority to do something for one day. And that exercise of authority on one day gives rise to a dispute. Well, it may well be that separate entity will be immune in relation to those acts. But we don't get to that point, we don't get to the right answer by looking in an abstracto how the state influences on a day-to-day basis the running of that separate entity. So the difficulty that may arise from hemisphere, which is not concerned with immunity, but certainly wanted to look to the law of immunity for inspiration, is that it's actually looking to the test which was devised for a very different purpose at a very different time, and that was during the time of absolute immunity. That's not the test that would be applied today with the restrictive doctrine. Now, the sentence in hemisphere which the courts below and the respondent now places an enormous amount of weight and significance is at page 660 of the bundle. And so, at paragraph 28, the point is being made that we should develop the rule, on the one hand, dealing with when, in what circumstances, you can enforce against the assets of a state enterprise in relation to a judgment against the state. And the point is being made that we should look at the more sophisticated, I think, rules of state immunity in looking at that particular question. But again, my point is, Trendex is not really appropriate for that purpose anymore. But the critical sentence is down the bottom of the page. It said this: the assets which are subject to waiver and to the commercial use exception in section 13.4 of the 1978 Act, protected by state immunity, should be the same as those against which the state's liabilities can be enforced. Now, the respondent and the Court of Appeal appears to rely on this to say that there must be a precise symmetry between, on the one hand, the circumstances in which a separate entity's assets can be enforced against to satisfy a debt of the state, and two, the circumstances in which a state entity's assets are protected by the state's immunity from execution. The sentence doesn't actually say that because it carves out the assets that will be protected by state immunity, so there's not symmetry in the way it's worded. But of course, if there were symmetry, then that would contradict the Christina line of cases. None of those cases were cited to the Privy Council in Hemisphere. So, in other words, we say that sentence cannot possibly mean that only assets formally owned by the state can be protected by immunity, because only those assets can be the subject of enforcement against the state. Not even the respondent goes that far on this appeal. Nonetheless, the Court of Appeal found that that was a sufficient basis to dismiss the appeal. And you'll see that at paragraphs 124 to 125 on the record, volume 1, tab 2, page 71. And it exposes a contradiction in the Court of Appeal's reasoning, because on the one hand they say that's sufficient, but on the other hand they consider whether or not there is an interest or control in the assets, which is not the same thing as looking at formal ownership. Again, taking my example of the state enterprise manufacturing fighter jets, can a creditor of the state enforce its judgment against the assets of the state, that state enterprise, generally? Applying the Hemisphere test to that question of substantive liability, the answer is likely to be no. Because unless the juridical personality of that state enterprise is so far lacking in substance and reality, then that state enterprise cannot be assimilated with the state. So that's the substantive liability question. So far, so good. But then we get to the immunity question. Well, can the fighter jets be protected by the state's immunity from execution? The answer to that question is likely to be yes. And it doesn't matter that they're not formally owned by the state enterprise. It doesn't matter that they wouldn't be available to satisfy the debts of the state under the general principle in Hemisphere. It doesn't matter that the state enterprise has a separate corporate status. What matters is that the fighter jets are being used for a sovereign purpose. And one would assume that the state, under general legislation, would have sufficient interest and control over them for the immunity to attach. And it shouldn't depend, my lords, on the precise analysis of the contractual relationship, perhaps between the state and the state enterprise, as to when title passes, etc. What should matter is that the fighter jets are being used for a sovereign purpose, and the state has manifested its control over those fighter jets by exercising its sovereign authority in some way.
You're taking here a situation where the state enterprise, which is a separate entity, has become liable for some debt.
Yes.
Yeah. And then there's an attempt to execute against its assets.
Or
No.
my hypothetical is where there's a judgment against the state.
I see.
Can it be enforced against the state enterprise's assets? No, according to the Hemisphere test. But that doesn't resolve the question as to whether or not you could enforce it against the assets that are formally held, owned by the state enterprise, which might include the fighter jets at a particular point.
But if you're postulating a judgment against the state, I can't see how you have any claim against the state enterprise's assets at all if it's a separate entity. How does the question arise?
Well, because of the Hemisphere test, but if we assimilate them on some more loose basis, then we might be in that territory.
But it slightly begs the question as to whether the assets are in fact assets which will be protected by state immunity.
Yes, and there is I mean, if we're talking about a warship, perhaps it's even easier, but there's a very, very long established principle of customary international law that you can't execute against a warship under any circumstances. So I'm assimilating a fighter jet in a similar situation. And it really does, as again, it really doesn't matter what the precise proprietary...
You could execute against a warship under construction in a commercial shipyard in support of a debt, a judgment debt owed by that commercial shipyard.
Because it's currently being used for a commercial purpose. Or it's not yet being used for a sovereign purpose.
Well, wait a minute.
But it's intended to.
Constructed for a
It's been constructed, but it's not in use.
But Section 13.2 contemplates intended.
Intended use.
Yeah.
Yes.
So,
But presumably the government contracts with shipyards provide that every time anything recognisably a ship starts to emerge on the way, it belongs to the government.
And if it happens to be a warship, my lord, it should be entitled to protection.
Well, I'm not sure they do contain provisions of that sort, actually, but
I mean, the difficulty is actually in getting one's head round your starting point, namely that warships are being constructed by independent separate entities with nothing to do with the state, I think. It seems all slightly unrealistic unless you believe in governments subcontracting their military enterprises, which maybe some governments in the world
well, warships
do.
are all constructed in the UK by commercial shipyards.
Yes.
Yeah, they're constructed by commercial shipyards, but...
And at a time when the warship is still the property of the commercial shipyard, if it was to go bust, it would be distributed to its creditors.
Yes.
Doubtless there would be very few takers that weren't states, and that might lead to certain practical results. But as a matter of law, the position was that they would be vested in the liquidator, who would realise them for the benefit of creditors.
My lord, if there was a fully functioning warship that was on a pre-delivery exercise to test whether its engines work properly, there is no doubt.
Now you're
that
altering the facts.
Perhaps I am.
It does depend, doesn't it, on who owns the warship?
Yes, it depends. It could still be on tests before it had been accepted by the government. It would
Precisely.
belong to the commercial enterprise.
Classic
Precisely,
example is
and-
Duncan and Camel Laird.
Yes.
And my lord, in that situation, we would say that it would be protected by state immunity,
Even though it was the property.
even though it was the property of the state enterprise.
Oh, it wouldn't have to be a state enterprise on this logic. It could be a commercial shipyard which was not owned by the state.
Precisely. And think of, to take that example, think of a private military company doing exercises in Iraq. There are going to be situations where a private company, which has no link to a particular state, is going to be exercising sovereign authority and may well be entitled to immunity in certain circumstances. My lord,
You say that there is no force whatever in the proposition that if a separate entity is set up to conduct trading, on the face of it, the other side of the coin is that it's unlikely, its assets are unlikely to be the property of the state. You say it all depends on an analysis of the degree of control.
It depends on analysis of the degree of control because it is linked to the fundamental question as to whether or not the asset's being used for a sovereign purpose. So the control has to be there to subject...
That's blurring the two questions. We go back to where we were this morning. I mean, it's got to be property before the question whether the assets are used for a sovereign purpose arises at all.
But my lord, my point is that one has to look to the reason why we have the concept property of a state.
Yes.
And the reason why we have it is to protect assets that are being used for a sovereign purpose. That informs the way we should interpret property of a state, and that's why control should be sufficient, because what it's all about is putting property in use for a sovereign purpose. There has to be subject to sovereign powers in some way. And my lord, as an example of a situation whereby you can come to the conclusion that property is the property of the government of Kazakhstan and the property of the Central Bank of Kazakhstan in the same breath, the IIG case, again, Justice Aikens as he then was. And you see this point conceded at the respondent's written case, paragraph 86, and that's what the finding was in that case. So it's quite possible for immunity purposes to say that two separate entities, the state on the one hand, a separate entity, the central bank on the other, it's the property of both those entities at the same time for immunity purposes. Of course, that doesn't work as a matter of property law, but it works as a matter of immunity law.
Immunity from what? I mean,
from execution.
Well, that, does the case at paragraph 86 support the words for execution?
My lord, we can go to the IIG case. It's a case precisely about execution. We had an ICSID arbitration award. They took it to London. They wanted to enforce against assets being held in London. And Justice Aikens then was found that they were property of the Central Bank of Kazakhstan, and they were the property of the state of Kazakhstan. The reason why it was more significant that they were the property of the Central Bank of Kazakhstan is that that meant it didn't matter whether or not they were being put to a commercial use, because for central bank assets they have absolute protection.
he talked about any right or interest, legal, equitable or contractual.
He was talking about what is property
Yeah.
in that particular case. And again, what wasn't really an issue was whether it was property of an entity or the other. Though, as I said, he came to the finding that it was the property of both entities for that purpose. The second proposition in their case on section 14 is back at 3.5 of their written case. And they say this will mean that if it is determined that Botaş has legal and beneficial ownership of an asset, that asset will be available for enforcement under the SIA unless either Botaş has a claim to sovereign immunity under section 14.2, e.g. because the proceedings relate to acts by Botaş in the exercise of sovereign authority, or the state can establish that it also has some legally enforceable proprietary or possessory title to or rights in or over the property in question. Now, my lords, this is a problematic proposition for a number of reasons. The first one is, how can immunity from execution depend upon whether or not Botaş has immunity from adjudication in section 14, subsection 2? Section 14, subsection 2 is about immunity from adjudication. And we know that for at least three reasons. One, it uses exactly the same terminology as section 1 in the Act. And there's no question that section 1 and the section that is dealt with under the title immunity from jurisdiction relates to adjudication. That's the first reason. The second reason is that section 14, subsection 3 follows subsection 2, and that does talk about immunity from execution. And the two only make sense if subsection 2 refers to adjudication and subsection 3 refers to execution. Basically, subsection 3 says, in circumstances where the separate entity consents to adjudication, notwithstanding its right to plead the immunity of the state under subsection 2, then its property is protected by the same privileges as would be accorded to a state under section 13. So these provisions only make sense if one's dealing with adjudication, the other is dealing with execution. The third point is that you'll see in subsection 2, it's in substance a test for immunity from adjudication. It's looking at the nature of the proceedings relate to something done in the exercise of sovereign authority. That's the classic test for adjudication. They're apt to cover actions, they're not apt to cover static things like property. So it's a test that just doesn't work in relation to property.
Well,
So
14.1 is concerned with the immunities and privileges conferred by this part of this Act and to whom they apply. And Section 13 is concerned with procedural privileges.
yes, my lord. Basically, every section until section 11 is under the title immunity from jurisdiction. Then from section 12 onwards, it's under the title procedure. And under the title procedure, you get to immunity from execution eventually in section 13.
Yes. Yes.
Could have been done differently, and some would say a whole lot more coherently, but that's
So
the way it was
really
done.
14.1 is telling us, so far as it's relevant to 13.2, that references to a state in 13.2 include A, B and C, but not a separate entity.
That's correct. So, my lords, the first part of this proposition doesn't make sense because the Republic's immunity from execution can't depend upon Botaş's immunity from adjudication. But then, in the second part of that proposition, in 3.5, they say, well, in any case, a state can assert its immunity from execution if it has a relevant proprietary interest. And of course, we don't agree with that formulation because it ignores the Christina line of cases. But the fundamental point is we get back to square one. We go through all those different steps in the argument and we get back to, well, is this property of the state for 13.2b purposes? My lords, I'm going to move straight along to finally the evidence of sovereign use. And I would...
How does 14.3 help? Because 14.3 is dealing expressly with situations where a separate entity would have been entitled to adjudicative immunity, isn't it?
That's precisely the point, my lord.
Yeah.
That's why subsection 2 cannot be dealing with execution as well. Subsection 3 would not make sense.
Well, it may be, but what it postulates is that the restrictions on execution, in particular in relation to the property of a state under section 13.2, only apply to separate entities where it has waived some immunity which it would otherwise have. Here we're dealing with a situation where it's conceded that the separate entity doesn't have any immunity.
My lord, it hasn't been conceded because there hasn't been an opportunity for Botaş to assert adjudicative immunity in respect of this particular question. This is purely an execution case. So,
Well, all right, I thought we were proceeding on the basis that Botaş could have been sued. I thought it had been sued. I mean, it's been held liable by arbitration awards and in court.
It's submitted to arbitration, my lord, but what subsection 3 does is give an entity protection if they could have asserted immunity and they didn't. And we're not saying that Botaş could have asserted immunity. That's simply not an issue.
Well, no, you're not, but as a matter of interest, I just wondered whether this doesn't rather cut against your argument, because it carefully provides that section 13.2 is only relevant to a separate entity if the separate entity is one which could have itself claimed adjudicative immunity.
My lord, it's simply limited to the case where it consented to adjudicative proceedings.
Yes,
when
but it
didn't
wouldn't be held liable at all unless it had somehow waived its adjudicative immunity. The point being made is that if you by me is that if you don't have adjudicative immunity, there's no equivalent which gives the separate entity the benefit of the section 13.2 relief against execution.
But my lord, it's not the separate entity in this case that's asserting any immunity. It's the Republic of Turkey.
No, but I thought you said 13.2 applies generally. Whoever the liability was established against. Indeed, that's the essence of your case, that
It certainly does.
the state can wade in, whereas on the face of it, section 14.3, I see, well, you'd say section 43 is only focusing on situations where the separate entity is being sued.
That's correct. So it doesn't cover the field, in other words. It's just limited to a very particular issue. And of course, it must be, my lord, because otherwise, if the state...
But these are proceedings where the separate entity was sued. It's precisely within the scope of section 14.3, isn't it?
It wasn't sued in Turkey.
Well, it doesn't matter where it's not sued. It's sued somewhere. These are dealing with proceedings anywhere.
But we have to distinguish between property which has no particular relationship with the adjudicative proceedings, which is exactly the case here. The shares weren't the subject matter of the dispute, and property that has been to which enforcement is being sought. So it deals with a very narrow issue, but it doesn't cover the field here. Wow. And it can't cover the field because suppose the state did have a solid proprietary interest in particular property of a state enterprise, which everyone agrees would be covered by the immunity, and that would mean the state couldn't assert an immunity. Evidence of sovereign use, my final part of the submissions. I would invite the court at its leisure to look at two documents. One is the certificate of the Ambassador of the Republic of Turkey to the United Kingdom, which attests that the assets are not being used for a commercial purpose, and that's on the record, volume 6, tab 59, page 1571. And the other is a letter that was submitted to the courts below from the Minister of Energy describing the sovereign uses that the property is being put. And that's on the record, perhaps we can just have that one in front of us, that's on the record at volume 6, tab 60, page 1572. And I'll just quote to you perhaps two short passages from that. That's at page 1573. And what I'm going to do is just very, very briefly, because brief is all I can be at the moment at this point, is look at BIL's participation in the Baku-Tbilisi-Ceyhan crude oil pipeline. The reason I'm going to stick to BIL is that this is BIL's only activity. So either it's sovereign or it's not. It's not about looking at different parts of what they do and seeing whether or not there's a dominant sovereign purpose. And it's common ground that it's its only activity. So this is what the Minister says. The BTC pipeline, it's about halfway down the page, is a crude oil pipeline which stretches from the Caspian Sea to the Mediterranean Sea. The BTC pipeline, which is the second longest of its kind, is the most significant component in the development of an east-west corridor for crude oil transportation, and is considered as a project of geopolitical importance. The way I can make good the geopolitical importance is to remind the court that the subject, the construction of this pipeline, inspired the plot of a James Bond film. There's nothing more geopolitical than that. The next paragraph says the BTC pipeline, which flows through Azerbaijan, Georgia and Turkey, is used as an aid to promote regional political stability and deepen relations with the United States and the European Union, who have a keen interest in international energy security. The BTC pipeline also reduces the risk of an environmental maritime disaster occurring in the Turkish Straits, which would directly affect Istanbul. My Lords, I just want to take you to three documents, either international agreements or contracts. The first is on the record at volume 12, at tab 111, at 3219. 3219. And this is the umbrella agreement between Azerbaijan, Georgia and Turkey relating to the BTC pipeline project.
Sorry, what page again?
3219. And you can see from...
What are we getting from these
what I want to show you...
Because this goes to the issue which is not before us.
It goes to the issue that's not before you. But what I want to suggest is that I didn't want to make all the submissions I'm making about the connection between the two tests and then not say anything about sovereign purpose.
You just want to give us a flavour.
And nothing more.
What this is saying is that the construction of the pipeline is a political project.
Correct.
And that's the point you're seeking to extract from it.
That's all I'm seeking to extract from this document.
It's designed to bypass Russia.
Sorry?
It's designed to bypass Russia, as I understand.
And Iran in particular.
And Iran.
I mean, presumably there are lots of projects which could be framed in those terms. Presumably there was some agreement with France about the Channel Tunnel.
The Treaty of
possibly
Canterbury.
Even
The Treaty of Canterbury.
Treaty of Canterbury, exactly.
My Lord, I'm not going to rest my submission on this agreement, I can assure you.
I mean, so far as it's relevant to the particular issue we're concerned with, we're not concerned with the status of what the company does, but with the status of its shares, aren't we?
Correct. And that's why I'm going to get very quickly, with your encouragement, to
Let's
the
go to
next
the
document. So I would just invite you at some point to read the preambles, what this whole project's about in the international agreement. Over the tab, the next tab, 1112, at page 3247, this is the host govern agreement. So it's the agreement between Turkey and the various entities that are involved in the construction operation of the pipeline. And you see from the whereas clauses on 3247, this is agreement entered in further to that tripartite agreement that I just took to you. And the important one for our purposes is the sixth whereas clause. It says this: the government acting on behalf of the state and the state authorities enters into this host government agreement empowered with the authority under Turkish law to direct and make commitments on behalf of the state and all state authorities to manage state assets, including the assets of state entities. The reason why this is significant is that this whole agreement is about what a state authority needs to do, and that state authority is none other than BIL. If we leave open that document for a moment, and I can show you how we see this, it's at the third...
This might have been highly relevant if you were submitting that it wasn't a separate entity, but it's common ground that it is.
Yes. So, my Lord, where I'm going to go with all this is that Bill is being used as a conduit for exercising sovereign authority in relation to this project. We'll see in a moment that it has powers to expropriate land. It has all sorts of powers that would be vested in the sovereign state. So it's essential, in other words, for Bill to remain the conduit for sovereign power. Otherwise, these agreements just don't work. And the irony is, my lords, this is Bill's only activity. If Bill's shares are worth anything, it's because Bill is doing what it's supposed to be doing under these agreements. These agreements are premised upon Bill exercising sovereign authority. They're premised upon Turkey being responsible for Bill's exercise of that sovereign authority. And so the paradox is, if they're taken out of state control, they're not going to have any value. So where we get to at the end of the day with all this is that Bill needs to be the conduit to sovereign authority. It is exercising sovereign authority. So those shares are being used for sovereign purpose because that's the conduit to the exercise of sovereign authority. And if that changes, they're not going to be worth anything. So if they're enforced against, we'll get to the point where they're not going to really have any value in the hands of a third party, and all that will be achieved out of this is a great disruption to the BTC project.
How do we know that Bill will cease to operate if the shares are executed?
Well, if I go through the provisions, it's just absolutely obvious, because they need to be controlled by Turkey in order to perform these functions, and Turkey is assuming responsibility. If we go to, sorry, I was going to take you first to demonstrate.
Well, that may affect the commercial wisdom of trying to enforce against these assets. I'm not sure it affects the legal status of the shares.
My lord, they are being used for a sovereign purpose, because they're allowing Turkey to delegate sovereign authority to the state authority, which is Bill, under these agreements. Bill, it's probably, it may be a matter in the past now, I'm not sure, but Bill at some point was responsible for expropriating land. And the Republic of Turkey assumed responsibility. Let's go to the provision then. If we're still at the host government agreement, at page 3256, we see here that the government guarantees to the other participants the state authority's obligations under the project agreements. And we'll come on to how I show you that Bill is the state authority in a moment, because that's the third document. Over the page at 3258, 6.2 says the government hereby represents and warrants, and you see at Roman numeral 5, the state authority is not granted or not obliged to grant to any person any rights or privileges that are inconsistent or conflict, or that may limit or interfere, etc., etc. Well, that's not an undertaking they could give unless they controlled Bill. If we go to 3261, 7.2, the government hereby covenants and agrees on its behalf and acting on behalf of and committing the state authorities that throughout the term of this agreement, we go over the page, the state authorities shall, this is at Roman 7, and then go to subsection 4, exercise such powers of taking, compulsory acquisition, eminent domain, or other similar sovereign powers to enable each of the MEP participants and their designees to receive and exercise the rights to land, etc., etc. So given that Bill's the state authority, it's contemplated here. Bill.
Well, we'll take submissions in order.
At Article 10, at 3278, we see that the government is obliged to compensate for any loss or damage which occurs because of any failure of the state authority, which is Bill, to satisfy any obligations under the project agreements, and including, in relation to Roman numeral 5, any act of expropriation by the state authority. So then, if we go to the third document, which is on the record at volume 15, tab 116, page 4138.
Sorry, tab
116
is that in 15?
at volume 15, 4138. If we go down 4 whereas clauses, we see, whereas the Republic of Turkey, in accordance with the host government agreement, that was the agreement that we were just looking at, appointed and authorised Bill to be the designated operator. And then the next whereas clause, whereas the designated operator is, in accordance with the host government agreement, a state authority, and accordingly this agreement is a project agreement. Now, again, this agreement is drafted quite clearly on the basis that Turkey needs to control Bill. And some examples of that: Article 9 on force majeure at 4169. Basically what this says is that Bill cannot rely on any sovereign acts of Turkey to excuse its performance. So if Turkey's initiated a war with another country, or government employees are engaged in a strike action, that doesn't absolve Bill from performance. And of course, it's obvious in that sense that Bill's being equated with the Turkish state. At Article 14 on dispute resolution...
Which article was that?
Article 9.
9 what?
9 which? 9.1 or 2?
9.1, yeah.
9.1, no, right.
When you get to dispute resolution, Article 14, it contemplates ICSID arbitration. And of course, ICSID arbitration only works if you have a private entity on one side and a state or a state entity on another. And you see at the top of 4179, this is section, or Article 14.2, so at the top of 4179, it says the designator operator, that's Bill, recognises that it has been designated by the government of the Republic of Turkey as a constituent subdivision or agency of the Republic of Turkey for the purposes of Article 25.1 of the ICSID Convention, and that the government of the Republic of Turkey has approved the consent of the designated operator to arbitrate disputes in accordance with the terms of the agreement. Well, that whole dispute resolution mechanism falls apart if Bill becomes a private enterprise. 1411. I was actually going to get to that myself. That 1411 says the designator operator hereby waives any claim to immunity in regard to any proceedings to enforce this agreement. Now, my point there would be, unless Bill was entitled to immunity, it wouldn't need to waive it.
Which clause was that?
14.11. Strange if Bill was waiving something it would never under any circumstances be entitled to. Of course, it's in relation to the enforcing the agreement, it's not in relation to its own shares. So, my lords, the point is, and I completely understand this may be of peripheral interest given that you don't have to decide it, but Bill's sole activity is in relation to being a state authority, designator operator under these agreements. It's clear that for that to work, it has to be a conduit for the Republic's control. And if it is taken into third-party hands, these agreements aren't going to work. Moreover, given that it is its only activity, one would expect the value of the shares to be worthless unless it is allowed to continue to perform this sovereign function under the agreements. And that's the paradox of this case. So we say, my lords, in summary, there is sufficient control and interest under Turkish law that I've taken you to, and I've only had time to look at Bill, but you can quite clearly see that these shares are being used for a sovereign purpose.
You say TPIC is the same, yeah?
TPIC is more complicated because it has different activities.
Yeah.
And so I expect that my learned friend, if he ever came to this, would say that some of those activities are commercial and others are sovereign. We may come to that on another occasion. So unless I can assist you with anything further, we are very close to 3 p.m.
Well, thank you very much indeed. You've done extremely well. Finishing even a little bit earlier. I don't suppose there's anything you want to say in 4 minutes, is there? Right, well, we will resume again at 10:30, and we will sit tomorrow afternoon until 3 o'clock.